But Trinsey versus Pagliaro is absolutely earth-shaking if you heard the holding of the court. What did we learn from Trinsey versus Pagliaro? What was the holding? And I guarantee it was one sentence. The holding of Trinsey versus Pagliaro: statements of counsel in brief or argument are not sufficient for a summary judgment. Did a light bulb just go on anyplace?
There's a case, Trinsey versus Pagliaro, that states that lawyers cannot testify.
Okay, so there's a popular myth among sovereign citizens online that, according to Trinsey versus Pagliaro, lawyers cannot testify in court. They basically can't say anything. Now, this particular myth, as we saw at the beginning of the video, apparently was started by Richard Cornforth. Now, a little bit of an aside, the reason why Cornforth got into the legal sovereign citizen guru game was because in 1992, one of his kids vandalized a Presbyterian church under, I believe, Oklahoma law. As the father of the kid, Cornforth was required to pay the church $2,500 for the damages to the court. Cornforth fought that lawsuit to avoid paying the church for the damage his kids did to the church, but ended up losing. But that's just an interesting point, because that's the reason Cornforth started investigating the law, because he was sued by a church after his kids vandalized it. Anyways, as you can imagine, the actual Trinsey case does not actually say that lawyers cannot speak in court. The Trinsey case is actually a case about a land deed, and the important bits for the purposes of this video are these two paragraphs. Quote, "There is nothing before us which would warrant a determination that the arbitration proceedings will in any way determine title to the land involved, notwithstanding the statement and argument that a counterclaim had been filed in the arbitration proceedings by a defendant." Moving on. "The defendant's motion to dismiss for failure to state a claim unsupported by affidavits or depositions is incomplete because it requests this court to consider facts outside the record which have not been presented in the form required by Rules 12b-6 and 56c. Statements of," now this is the line that they only quote, "statements of counsel in their briefs or arguments while enlightening to the court are not sufficient for the purposes of granting a motion to dismiss." In other words, what Trinsey actually says is that the court cannot make a ruling simply based on on statements made by lawyers. In order to make a ruling, a court needs facts submitted in the forms required by Rules 12b-6 and 56c, and they need affidavits and depositions. It can't simply be because the lawyer said so. That's all that Trinsey says. It does not say that lawyers can't say anything or submit anything. Now, as you can probably imagine, a whole bunch of people have gone to court using Cornforth's Trinsey argument only to end up losing. For example, we have Sundsmo v. Calkins, which is a Wisconsin case from March 14, 2016, in which the guy used the Trinsey argument. Quote, "Plaintiff cites Porter v. Porter and Trinsey v. Pagliaro to support his argument that defendants improperly filed their materials, but he misreads both cases. In Trinsey, the court stated that statements of counsel in their briefs or argument while enlightening to the court are not sufficient for purposes of granting a motion to dismiss or summary judgment. This is an uncontroversial statement that argument by counsel is not the same as evidence. There is nothing improper about counsel submitting proposed findings of fact as long as counsel follows this court's procedures by explaining what evidence supports each proposed finding." We also have KeyBank National Association v. Todd D. Harrison, which I believe was a foreclosure case from Ohio 2015. Quote, Harrison claims that the trial court erred in denying his motion to dismiss and strike KeyBank's motion for summary judgment. In his motion, he argued that statements of KeyBank's counsel were insufficient to support the motion for summary judgment. Harrison cited, among other cases, Trinsey v. Pagliaro. This court did not expressly rule on this motion, but it implicitly overruled the motion by granting KeyBank's motion for summary judgment. In this appeal, Harrison argues, citing Trinsey, that the trial court erred in denying his motion to dismiss and strike KeyBank's motion for summary judgment. Trinsey involved a dispute between two individuals regarding title to property. Of relevance to this case is a statement in Trinsey that statements of counsel in their briefs for argument, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. Here's the rebuttal by the court. While Harrison is correct that unsworn statements of counsel are not evidence to support a motion for summary judgment, that principle did not require the trial court to overrule KeyBank's motion. KeyBank supported its motion with the affidavit of Michael Bitterman, Assistant Vice President of BHH Morgan Corporation, the servicing agent for KeyBank, and other documentary evidence. This trial court did not err in ruling on the motion for summary judgment. Next up is Anderson v. Deutsche Bank National Trust, which is from Illinois, 2014. Quote, Anderson's only response is the one noted in this opinion, first paragraph, that attorneys cannot submit evidence without a verified affidavit. That's not what the only case she cites, Trinsey v. Pagliaro, says, but in any event, defendants' Rule 12b6 motions do not submit evidence. Rather, they make legal arguments as to the complaint's legal sufficiency, taking all well-pleaded facts as true and properly considering documents attached to the complaint, documents that are critical to the complaint and referred to in it, and information that is subject to proper judicial notice. And finally, we have Citibank South Dakota v. Otto, which is a Minnesota 2008 case. Quote, Appellant next argues that the district court relied solely on the statements of counsel in briefs, memoranda, and oral arguments as the basis for granting respondent's summary judgment motion. Appellant relies on Trinsey v. Pagliaro in support of his argument. The court in Trinsey held that statements of counsel in their briefs or argument, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. However, this holding was in reference to a motion to dismiss that was unsupported by affidavits or depositions. Respondent's summary judgment motion was supported by affidavits as well as other evidence. There is nothing in the record to show that the district court relied solely on the statements of counsel in granting respondent's summary judgment motion. So in summary, the sovereign citizen Richard Cornsforth interpretation of Trinsey versus Pagliaro, in which they believe that it basically says that lawyers can't say anything or testify in court, is basically false. The true interpretation of Trinsey v. Pagliaro is that a court cannot rule solely on something that a lawyer says. In order for court to rule on something, a lawyer needs to present his arguments and support it with affidavits, depositions, documentation, evidence, and all that stuff. Which should be obvious, it shouldn't even need to be pointed out.